Hi everyone, I'm Andrew Price, co-head of Norton Rose Fulbright's Commercial and Energy Disputes practice here in the United States. And welcome to Texas Business Court Insider. Hit the link below to subscribe and receive all of Norton Rose Fulbright's updates that track the developments in the Texas Business Court.
And I'm Kate Ergenbright. I'm a commercial and energy litigator based in Houston. Make sure you check out our Texas Business Court Insider Hub. On the Hub, you'll find our latest thought leadership on the Texas Business Courts and beyond, as well as other videos like this one. The link to the Texas Business Court Insider Hub will be in the caption below this video.
So Kate, today we're going to tackle an issue that's been top of mind for anyone doing commercial litigation in Texas since the establishment of the Texas Business Court last year, and that is, what are we going to do with all of these cases that satisfy or seemingly satisfy the business court's jurisdiction, but they were pending at the time the Texas Business Court opened its doors on September 1st, 2024? Why has this been such a big issue?
Well, it matters, Andrew, because before September 1st, 2024, the business court didn't exist. So there was no business court for litigators to remove their cases to. And so the big question, as you said, was when the court opened, if I've got a case pending somewhere else in a state court in Texas that otherwise would be removable to the Texas Business Court, can I move my case? And a lot of people tried to do that. So in the first approximately 60 days of the court's existence, more than half of the cases that were removed to the Texas Business Court were cases that had already been pending in another Texas court before the court had even opened. And the justices on the court began issuing orders requiring jurisdictional briefing on this issue and holding hearings and issuing orders. So we're filming this video on April 11th, 2025, a little over 7 months since the court has been in existence. Andrew, do we have an answer to this important question?
We do, and the business court has been very consistent, kind of uniformly holding that cases that existed prior to September 1st, 2024 cannot be removed to the Texas Business Court. Now, there's been some developments, though, and some kind of things around the edges that I think are interesting that we'll get into. But generally speaking, you can't remove these cases to Texas Business Court. And so I guess the question might become, well, why? Well, first things first, a lot of these removals that you described were opposed, right? So the defendant tried to take it to Texas Business Court, the plaintiff opposed it and wanted to enforce what they believed was their right to go back to district court and enforce these jurisdictional limitations. However, there also were cases that kind of started picking around, well, what if there is an agreed removal? Or what if there is a removal and the plaintiff withdraws their opposition and later consents to the removal? How does that work? And so the court started delving into those questions and really looking at the statute. And it turns out that what really became key in that regard was Section 8 of the enabling statute. Now, this part of the bill didn't get codified. It's not actually in the codified statute, but it was in the enabling legislation. And it's Section 8, and I want to read it so that I get it right, and then we can talk a little bit more about it. Section 8 says, the changes in law made by this act apply to civil actions commenced on or after September 1st, 2024. And so that language, which the business court frankly referred to as a bunch of different things, effective date, timing provision, and some other things, not exactly consistent in how it was described. Ultimately, the Texas Business Court interpreted that provision as a subject matter jurisdiction limitation on its authority to hear cases. And so as we all know, subject matter jurisdiction is not something that the parties can agree to. The parties can't agree that a court that wouldn't otherwise have subject matter jurisdiction, oh, you can go ahead and hear our case. And so once the court decided that Section 8 was a limitation on its own subject matter jurisdiction, then it didn't really matter that some of these parties were agreeing or withdrawing consents or wanted their case to be heard in Texas Business Court. Now, there is one case up right now that we are involved in full disclosure, called Lone Star versus Eagle Claw, where prior to removal, we agreed with the opponent and executed a written agreement, a subsequent agreement, where we said, we want this to be heard in business court. We agree that it can be heard in business court. The parties waive the timing provision in the statute. We went ahead and removed it by agreement. The business court asked for briefing. We had a hearing, and we got remanded. We did ask the court to allow us to permissively request that the 15th Court of Appeals hear the case. She said okay. We requested the 15th Court to take the issue up. They've agreed to do that, and we're actually going to have oral argument next week here in Houston. So we'll keep everybody posted on that. But it's an interesting question that's really going to go to the heart of whether or not this is a subject matter jurisdiction limitation or whether it's simply a timing provision or effective date provision that, frankly, the parties can agree around or waive. Kate, there's been some other issues, though, that are equally interesting related to removal and what can and can't be removed. How are those things turning out?
Yeah, Andrew, you're right. The court has analyzed what happens when the nature of a case, either the claims or the parties, changes materially after September 1st, 2024. Now, in one of those cases, the court, the parties, both the plaintiff and the defendant, filed new claims after September 1st, 2024. And the plaintiff tried to remove those newly filed claims to the Texas Business Court that the plaintiff believed were otherwise removable. But the court remanded those claims, holding that it didn't matter when the new claims were filed, didn't matter that they were filed after the court had already begun taking cases. What mattered was when the case that those new claims were filed in was initially filed. Going back to this civil action language and the enabling act that you referenced earlier, the court held that what mattered was when the civil action was filed, not the removed claims themselves. In the other case, there were both new claims and new parties. That was what started out as a divorce proceeding. The couple getting divorced filed derivative claims on behalf of a company that they were part owners in and some other third-party claims against entirely new defendants who were not defendants to the case before September 1st, 2024, were only added after the business court had begun taking cases. And those new defendants tried to remove the claims against them to the business court. But again, the court remanded the claims, holding that it didn't matter that those new claims and those new parties were added after September 1st, 2024. What mattered was when the divorce proceeding was initially filed, when that civil action was filed, and because it was filed before September 1st, 2024, the court held it had no subject matter jurisdiction to hear even the new claims and new defendants that were added after the court opens its doors. Now that case, the new defendants have mandamused that order, and it'll be an interesting one to watch that we'll keep you all updated on.
Yeah, for sure. Particularly the last one you just discussed, the idea that a new defendant essentially doesn't have the right to get the case into business court, even though they got added after September 1st. They essentially lose what would otherwise be their right to take the case to business court just because they got added to an old case. Very interesting. We'll keep an eye on that one. Well, thanks again, everybody, for tuning in to Norton Rose Fulbright's Texas Business Court Insider. We look forward to seeing you next time.